remedy. So can anybody tell me basically what constitutes a false imprisonment? And it's real easy. What's good about this? It's not some legal mumbo jumbo, which is extensive, which dulls the brain. I don't know. I'm sure all of us on this call has read some degree of statutes and legal things. And for me, sometimes if I'm not alert, it just almost puts me to sleep. And I think it's designed purposely that way, the way it's worded. Anyway, false imprisonment is interfering basically with a man's freedom of going from point A to point B when he doesn't want to be restrained, when he's not permitted to go where he wants to go, or he is brought to a place where he doesn't want to go. So I'll just read a few here just for review. Let's see here. These are from some court cases. False imprisonment is the unlawful restraint by one person of the physical liberty of another, and as here used, the word false seems to be synonymous with unlawful. So false imprisonment, it could be equated with an unlawful imprisonment. Here's another one. Any exercise of force or expressed or implied threat of force by which, in fact, the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is the unlawful arrest or detention of a person without warrant, or by an illegal warrant, or a warrant illegally executed. And Mr. Weisman is going to elaborate on that in later chapters. Any restraint, however slight, upon another's liberty to come and go as he pleases constitutes an arrest. Okay, so now we have an idea of what constitutes a false or unlawful imprisonment. It's pretty simple. Here's a little review of length of time requirement. The tort or wrong of false imprisonment occurs. Tort is an invasion of someone's right or a violation of someone's right. So false imprisonment occurs in the instance that one is restrained in the exercise of their liberty. There is no unreasonable length of time for a restraint before the tort can be claimed. That's good stuff. Here is a quote from a court case. False imprisonment at common law and elsewhere consists in the unlawful detention of a person of another for any length of time whereby he is deprived of his liberty. I think I mentioned this on the call last week. I believe this includes when a corporate policy enforcer puts on his lights to pull you over. At that moment, that is a false or unlawful arrest, which is linked to a false imprisonment because he's interfering with your right to move in the manner you desire to, without any lawful grounds. All right, so we're going to... Does anybody have any questions up to this point regarding this little review? If not, we'll just take it, continue from the section titled Malicious Prosecution. So, in many cases of imprisonment... Oh, I'm sorry, did anybody have a question or comment? I don't think I gave enough time for that.
Yeah, what page is that?
I believe it's page 9. I'm sorry, page 7. Now, if you're using a PDF, if you have the PDF in Adobe Reader, I think it's 9 according to Adobe, but within the PDF itself, it's 7. Is that right, Chris?
That is correct, Peter.
Alrighty, we will continue on. So in many cases of imprisonment or wrongful arrest, there has often been a misunderstanding made between the charges of false imprisonment and that of malicious prosecution. While both may often involve a restraint of one's liberty, the two charges are not interchangeable or synonymous. There's a fundamental difference between these two charges. They are made up of different elements, enforced by different forms of action, are governed by different rules of pleading, evidence, and damages, and are subject to different defenses. That was a quote from, I think, a court case. Now, for some of you who don't know about some legal process, it's mentioned here where he says they are made up of different elements enforced by different forms of action. For any proper case for a court to have jurisdiction, there has to be a proper cause of action, and within that cause of action there are elements to support that cause of action, which then he goes on to are governed by different rules of pleading, evidence, and damages. So within a case, there has to be a cause of action, an injured party, there has to be elements of the cause of action, and there has to be damages that are brought forth. So, because the courts exist solely to settle controversies. So obviously, as a damaged party, and a damaged party is bringing forth damages by which they're seeking remedy. And that's what we're seeing here. So the cause of action for us, if we're pulled over by a corporate policy enforcer and they do their nonsense on us, well, we have a cause of action. We'll go into the elements and damages, and then the remedy to be able to recover from the damages. So he's saying that they're subject to different defenses. So there's a little difference between malicious prosecution and false imprisonment. We continue. One description of malicious prosecution is as follows. Malicious prosecution is an action ex delicto for the recovery of damages which have proximately resulted to person, property, or reputation from a previous unsuccessful civil or criminal proceeding, which was prosecuted without probable cause and with malice. I had to look up that word ex delicto. Usually I don't care about legalese, but I looked it up, and it's a Latin word which means from a wrong or from a transgression. This legal term indicates a tort in modern usage. You know, these people like their word salad, their word nonsense. All right, back to the treatise. In an action of this type, the burden rests upon the plaintiff, the one bringing the suit, to establish each and all of the following propositions before being entitled to recover. Namely, he was prosecuted in a criminal proceeding or civil suit. Defendant instigated such prosecution. The prosecution terminated favorable to the accused. Defendant acted without probable cause. Defendant acted with malice and damages that were caused. So if we rewind back here a little bit, what did I want to go over? So in false arrest or false imprisonment, when a plaintiff brings that, which really we probably should use the word claimant instead of plaintiff. I think plaintiff is a legal term. But nonetheless, in a false arrest and false imprisonment, the burden of proof is not on the plaintiff or the claimant. Usually that's how a suit goes or a court case goes. The plaintiff has to bring forth the evidence. In the false arrest and false imprisonment, that is incumbent on the defendant. But in a malicious prosecution, the defendant doesn't have to prove that it's a malicious prosecution. The plaintiff or the claimant has to. Okay, we'll continue on here. In Indiana, a case arose where a man sued several officers for unlawfully arresting and imprisoning him in the county jail. Sounds familiar, doesn't it? And without any charge preferred against him. The defendants insisted his complaint was bad as it did not allege that the imprisonment was malicious and without probable cause. The state Supreme Court rejected this claim. There is a marked distinction. Now, this is a quote from this state Supreme Court case. There is a marked distinction between malicious prosecution and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious prosecution. If it has been extrajudicial without legal process, it is false imprisonment. So what do you think when we get pulled over or when these corporate employees harass us? What do you think that probably would be most likely? A malicious prosecution or a false imprisonment or false arrest? I would say it's probably a false imprisonment, most likely. All right, let's continue on. An arrest or imprisonment can be malicious or false, but not both. In a case of malicious prosecution, the arrest or detention is procured from malicious motives.
Peter.
Is this
Hi.
Maria?
Yeah, hi.
Hi, nice of you to
Sorry.
make it.
I couldn't get unmuted fast enough to get this comment in.
Oh, yeah, go ahead.
When they pull you over for a taillight that's out or whatever, there's never any, oh shoot, now the term goes out of my head.
Probable cause?
There you go. Yep.
Yeah.
No probable cause a crime has been committed.
Yes, and we know that.
That's it.
I think probable cause is abused by these corporate employees, where I don't remember. I think Mr. Weisman may elaborate on that later on in the treatise. But, I've just been giving it some thought lately about what probable cause really is. And it seems like, as we're going to get into this further, that probable cause can only be based on these policy enforcers witnessing you committing a felony or breach of the peace. Or there is an actual lawful warrant out for the man or woman. Other than that, there's no really other probable cause. Now, don't quote me on that. I mean, that makes sense to me because that narrows it in according to what's on the books, rather than these guys just coming up on the spot and going, well, statute blah, blah, blah. Well, that's not probable cause. Or I saw, you didn't stop fully at a stop sign. I don't believe that's probable cause.
Probable cause is a felony.
Right.
Got to be felony probable cause, not misdemeanor.
Right. I think that's important to know because obviously, I've experienced it. I'm sure some of you guys on this call have experienced their lame probable cause excuses or thinking they're going to pull a fast one. Well, as we're learning here, they won't be able to do that anymore. So anyways, anybody else want to weigh in on this? I'm going to step away for a minute. I have to get something to drink. Converse among yourselves. I'll be right back.
So one of my first questions when I get pulled over is what is your probable cause?
Yeah, and where's the warrant?
I have one that I have used. I asked the officer, sir.
What did I miss? Anything?
Oh, Dave was just about to give us an input.
Who?
Dave.
Dave?
Dave. Hi, Dave. Welcome.
Yeah.
Yeah, go ahead.
Yeah. I used a little bit of David Straight's thing. I congratulate the officer on being there and ask him, does this have anything to do with traffic? And he's going to probably say yes. I said, oh, are you trying to engage him in a commercial contract?
Have you used that?
Changes the whole ballgame. Yep. I have my name copyrighted.
When I was pulled
so if he puts
over,
my name down on his ticket, it's going to cost him out of his back pocket.
Yeah, if it's possible to keep these people accountable, yeah. When I was pulled over last June, I asked the man masquerading as a peace officer, "Do you have any evidence that I'm engaged in a commercial activity?" because that's the only reason why, those are the only people they can really deal with, is those who are engaged in a commercial activity. But anyways, anybody else? All right, let's march on. So I'm going to take it for you, those of you who are following in the PDF, just after that, that court case quote. An arrest or imprisonment can be malicious or false, but not both. In a case, so that's important. In a case of a malicious prosecution, the arrest or detention is procured from malicious motives and without probable cause, but was done under lawful process. Whereas in false imprisonment, the detention is without proper legal authority. Now, again, I think I mentioned this last week. I have a problem with that legal authority. That requires that needs to be defined, because if they're going to use legal authority, then we really don't have a leg to stand on, because they're just going to be going by their statutes. That's if that's what that means. But if that means lawful authority, I could see the distinction there. So we'll continue reading. One may be legally arrested for some alleged reason, but done maliciously. If he is found to be not guilty, he then has a case for malicious prosecution, but not false imprisonment. If the arrest is not pursuant to legal forms of law, whatever that means, then whether he is guilty or not, he has a case for false imprisonment, but not malicious prosecution. If this is done with malice, it would add punitive damages to the suit. In describing the distinction between these two charges, the Supreme Court of Oregon stated that foundation of the cause of action, there we go again, cause of action, for false imprisonment is the right which even a guilty man has to be protected against any unlawful restraint of his personal liberty, while a malicious prosecution case is founded upon the right of an innocent man to be compensated in damages for injury he may sustain when a groundless charge is brought against him, even though such charge may be presented and prosecuted in accordance with the strictest forms of law. In other words, the want or the lack of authority is an essential element in an action for false imprisonment, whereas malice and lack of probable cause are the essentials in an action for malicious prosecution. Interesting. What do you think is meant by the want of authority? Does anybody have any ideas regarding that, or the lack of authority? How would that look in real life? Does a policy enforcer have the authority to pull someone over? That could be rhetorical. I mean, anybody really can answer that if you want. That's really what it boils down to. According to that false arrest and false imprisonment, if we're going by the law of liberty, no, he doesn't. And that's the whole contention. They don't have authority. And they think they do. Anybody want to weigh in on that?
Yeah, I got a quick example. I had a couple of bad actors approach me in a parking lot and tried to ID me. They lacked the authority to do so. And ultimately they were unsuccessful, but that's just an example.
Yeah. Why do you think they lacked authority?
They had, there was no suspicion of a crime, no warrant with my description, no breach of the peace.
There you go.
There's no harm, injury, or loss caused or by my actions or inactions.
And they infringed on your liberty.
Exactly, and I tried to inform them that this constitutes an arrest, and he wanted to argue with me, and I was going to unload on him and explain it, and then I just buttoned my lip.
Yeah. Yeah, it'd be good to maybe do some role playing or look at this a little deeper and think about actual scenarios and how we would handle them dealing with these people. Because obviously, I think it's quite clear that they're not going to listen. But at the same line, you know, I think it's important that we establish the record, regardless whether they know or not, and to do that effectively. Anybody else? All right, we'll continue on. Somewhat different to the wrong of malicious prosecution is a charge of abuse of process, which is the misuse of legal process for an ulterior purpose in which malice or ill will may also be a factor. And it seems like this is what Chris Ripple is dealing with. Wouldn't you think, Maria? I don't know, is Chris on the call? I don't think Chris is on the call.
Yep,
is she out there?
We're both here, actually.
Oh, hey, Chris.
Hey, blessings, everyone.
So when I read that, I think of you, of what you just went through, that last paragraph that I read. I'm not saying this in a kidding way. It's, you know, it's serious. This is what you went through. Misuse of legal process for an ulterior purpose, in which malice or ill will may also be a factor. That's what it seems like from the affidavit that Maria shared with us the other day. I guess the affidavit, the bogus affidavit for the warrant that they tried using against you. Would you agree with that, Chris, or do you have any other thoughts on that?
No, yeah, no, it's absolutely true.
Yeah,
we've kind of been in the process today of writing up and doing the rebuttals to all of it and proving the erroneous portions thereof.
If you don't mind me asking, what's going on with that up to this point?
You want to give him an explanation of
that? Since you asked, it's pretty timely. I thought I might read the introduction and the paperwork later on when we're all done with the study, and it kind of explains everything.
Okay. Sounds good.
Yeah, but the short story basically is just that the court invited him to put paperwork in. So.
And that's a good thing. Is that a good thing?
I mean, it's the best thing we could have ever expected from them. So, but being good, I don't know if it's good. Good would mean they'd follow the law. So, yeah.
Right.
Yeah.
All right. Yeah, maybe we'll touch upon that later on.
Okay.
All right. We are proceeding to Chapter 3. Arrest without warrant. Chris, does that sound familiar? So the law of the land, the authority to arrest without warrant was rather limited and well-defined at common law, a law which has been made part of our constitutional law and the due process provisions. The common law rule on arrest is based on common sense. As a general rule at common law, an arrest cannot be made without a warrant. Pretty straightforward. Thus, the right to arrest a person without a warrant is an exception to the general rule. This simple rule was expressed by Justice Carpenter in delivering an opinion for the Supreme Court of Michigan as follows. The law governing this case is elementary, except for a breach of the peace, there we go, committed in his presence or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony, a police officer has no authority to arrest without warrant. There we go. There's the trifecta right in this opinion. What is the trifecta? For let's say this, what is the trifecta for? Lawfully arresting or imprisoning someone. Breach of the peace, a felony, and a lawful warrant. We keep those three things in mind, we're going to be in a good position to keep these people in check. All right, so we'll continue on. The objective in this law was to have a balance between preserving liberty, yay, and preserving the peace, woohoo. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of the peace could also be summarily, is that right? Summarily? Sounds weird.
Summarily.
Yeah, summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrest had to yield to the liberty of the citizen. The liberty of citizens is too sacred to be left to the arbitrary will of men. And we could also call in that word citizen into question. But nonetheless, we get the point. Everyone knows what felonies are. I don't know about that. The most common felonies are murder, rape, kidnapping, sodomy, abortion, treason, and arson. Does anybody need any of those defined? A breach of the peace is obvious and well known. Therefore, everyone's liberty was safe since all knew for what they could and could not be arrested. But where is the safety in one's liberty if they are to be subject to every ordinance or law that legislative bodies may choose to enact? Or if the law on arrest can be changed by statutes, which is really changed by the crazy will of men, wicked men. By the Due Process Clause, the common law governs what the law on arrest is in this land, and where it exists, the most statutes can be as declaratory of the common law. If there's no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinance. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. Now, what I want to do is I'm going to depart here for, I guess, several minutes. Maria, were you able to get, I sent you the history and definitions on false arrest and false imprisonments from the American law of torts. Did you get that out to anybody?
No, but right now I'm composing an email that has everything you've sent to me so far in the same email. So when did you send that? I'll put that in right now.
I'd have to go through my email.
Approximately.
A few days ago. A few days to a week ago, I think.
Yeah. Okay.
All right,
I'm going to send it out right now.
Okay. I'm going to, back up a little bit, and Maria's going to get, for those of you that are on her contact list, she'll get this out to you. Now, I got this when I did some research at the local law library where I'm at, and this is from the American law of torts. It wasn't really anything specific for Pennsylvania, but within this link, there are quotes from court cases from a lot of different states, which mention different things. So I'm just going to go through how it's defined in this lawful dictionary, and we'll just proceed from there. False imprisonment. I wanted to go through this before we actually got into the warrant issues. False imprisonment, including the tort of false arrest. Intentional and unlawful violation or total restraint of a person's liberty is an ancient tort pursued under the common law by the writ of trespass viet armis, and is an injury largely mental to the person. Wrongful, unlawful, or willful detention is the basis of the claim or cause of action. And the cause of action is universally recognized. It's a good thing. The elements of this wrong must be properly and sufficiently established. There have been and continue to be a great many cases strenuously litigated. It is an older decision, definition, and nature. In addition to the very numerous cases already cited, false imprisonment has been said to be the unlawful restraint by one person of the physical liberty of another. There's also a substantial number of decisions containing some express pronouncements that false imprisonment consists of a direct restraint without legal justification. False imprisonment was defined in older statutes as the unlawful violation of the personal liberty of another. And under this type of statute, whether the offense was treated as a tort or crime, the definition was the same. Let me go down here. It says malice and absence of probable cause as not being essential elements. In an action for false imprisonment, the plaintiff does not need to allege malice or the absence of probable cause on behalf of the defendants in order to recover. Let me read that again. In an action of false imprisonment, the plaintiff does not need to allege malice or the absence of probable cause on behalf of the defendants in order to recover. I mentioned that earlier. This is one of the unique situations where the onus is on the defendant. Okay, here's a case. False imprisonment consists of depriving a person of his or her liberty without lawful justification. To prevail on a claim for false imprisonment, the plaintiff must establish the defendant restrained the plaintiff, the restraint was intentional, and the restraint was unlawful. You think we could establish that when a policy enforcer pulls us over? Yeah, we could establish that we're restrained by the plaintiff. He stopped us from our liberty from going from where we want to go. The restraint was intentional. That's obvious. And it's obvious the restraint was unlawful. So that's a good thing. Now, when you guys get this PDF, like I said, there are a lot of cases from different states. I highlighted some aspects of some of these cases. I'm just going to go ahead and read those because a lot of these cases, they seem repetitive. But nonetheless, you can see this is all over the country. Cases like this have popped up, and they're fairly recent cases. They're not too old. They're not like from the 1800s or 1700s or anything. Let's see here. What happened to my highlights? I thought I highlighted this stuff. I guess not. I guess they disappeared. Let's see here. Here's some from Pennsylvania, 1982. When a defendant purports to act to administer the law without legal justification, as plaintiff alleges here, false arrest is not an independent ground of liability, and false arrest and false imprisonment become synonymous. Therefore, we will begin our discussion by analyzing the elements of false imprisonment. In addition to unlawful activity, Pennsylvania law requires acts intending to confine another within boundaries fixed by another that directly or indirectly result in such confinement of which the plaintiff is conscious or by which the plaintiff is harmed. Confinement may be effected by physical barriers or physical force, by submission to a threat to apply physical force, or by taking a person into custody under an asserted legal authority. There's a lot of stuff here. The plaintiff must make some request to leave, which request is denied by the defendant. That is, plaintiff must attempt to determine whether his belief that his freedom of movement has been curtailed has basis. There's a lot of stuff here. I'm kind of disappointed because I highlighted some cool stuff. But we get the point. When you guys get that, PDF, you can go through it. All right, back to the treatise. Where were we here? Chris, where did we leave off? I forgot.
Give me just a second.
I think we're on page 9.
We are on...
Right column about the middle?
Yep, exactly.
I'll just take it by what it says by the Due Process Clause. So by the Due Process Clause, the common law governs what the law and arrest is in this land. And where it exists, the most statutes can be is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinance. That's what these people like to depend on. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. Wrongdoers. The following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and a complaint which need to be served upon the defendant and the court. There's also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years on this matter. Now, the only thing I have, he gets in here and he gives some actual paperwork filed in the court. Me in particular, I have a problem with the word plaintiff. That's just me, because it's more of a legal position in their legal jurisdiction rather than keeping it on the law side outside of that legal jurisdiction. Does anybody have any other ideas regarding that? Instead of it calling a complaint, we call it a claim. And obviously, the claimant is making a claim.
A man makes a claim. A person makes a person complains. Yeah,
and you guys, some of you guys know me that I take it to the biblical foundation where believers. I think anybody could correct me if I'm wrong. We're not really allowed to complain, nor are we. It's not wise to complain or argue. One of the scriptures I use to justify that, I believe it's Philippians chapter 2, verse 14 or 16. Let me just double check here real quick. And this is where, the Bible comes into play in our actions, even dealing with these people. Philippians chapter 2. Is it 14? Yeah, it's 14. It says, do all things without murmurings or disputings, or it's do all things without complaining and arguing. So we make claims. We don't argue. We don't complain and argue. So that's the way I would approach it. How that would fly, I don't know. But does anybody want to weigh in on that? Any other ideas? I don't know if I want to go through. Why don't we do this? Let's just go through this sample paperwork to get an idea of. I don't know if this is a real occurrence, but nonetheless, it'll probably reflect a real occurrence. So I'll just go through this paperwork. If anybody has any questions, just jump in. So, State of Minnesota, County of Hennepin, which I want to say something on a side note. This state of and county of, I believe it represents a corporate entity, not a de jure government. I think everybody's aware of that. It says District Court, 4th Judicial District. Charles A. Weisman, plaintiff, versus Mark L. Fanning, defendant. So I guess this might be a real thing. Plaintiff for his complaint against defendant states and alleges, number one, on September 30th, 1992, plaintiff was traveling in his automobile on a public highway called I-35 West between Richfield and Minneapolis, going northbound, when stopped by the defendant acting as a highway patrolman. Chris, did you say there? Didn't you call them actors? An employee of the state of Minnesota Number 2, the defendant asks plaintiff to see his driver's license. The plaintiff explained that he's not a licensee under any board or commission and is not required to be a licensee. The defendant insisted that the plaintiff must have the said license. That sounds familiar. Number 3, the defendant then arrested, searched, and handcuffed the plaintiff. That's familiar too. Without warrant and over his objections that defendant's acts were in violation of plaintiff's rights and the constitutional provisions of due process of law. Most of us have been there. The defendant gave no specific charges to the plaintiff for his being stopped or for the arrest, nor did he advise him of his rights as shown in the defendant's field report, which contained only traffic misdemeanor charges. A copy of this report and an official complaint was received by plaintiff 2 months after the arrest. Number 5, the defendant brought the plaintiff to the Hennepin County Jail, where the defendant knew that the plaintiff would be subject to booking, which included fingerprinting, photographing, and confinement for an indefinite period of time, and possibly be subject to other types of assaults and batteries. Number 6, further, the plaintiff, by his own admission, made no attempt to bring the defendant before a magistrate or judge, and he had full opportunity to do so, being that the arrest occurred around 10:50 a.m. on Wednesday. Number 7, defendant, acting on his own accord and without warrant or court order, had the plaintiff's automobile towed to an impound lot and put it on a hold order. That's happened to me a few times. Number 8, realleges paragraph 1 through 7. Number 9, on September 30th, 1992, the defendant, policy enforcer, without warrant or due process of law, Minnesota Constitution Article 1, Section 7, unlawfully arrested the plaintiff, and acting contrary to law, did falsely imprison the plaintiff, depriving him of his liberty. Pretty straightforward. Good stuff. Number 10, as a result of the defendant's false imprisonment of the plaintiff had his right to liberty violated, suffered mental anguish, a loss of time and wages in his work, and a discredit in his reputation by his failure to attend a scheduled meeting. That was count 1 of false imprisonment. Count 2 of false imprisonment. Number 11, plaintiff realleges paragraphs 1 through 7. Number 12, the defendant, upon arresting plaintiff, brought him to the county jail for the purpose of booking and detaining him, and by his own admission made no attempt to bring the plaintiff before a proper judge or court as is required by due process. Number 13, the acts of the defendant in deciding how to deal with the plaintiff after his arrest and failing to take him to a judge or court to so decide constitute false imprisonment by the defendant under the law of the land. Minnesota Constitution Article 1, Section 2. Count 3, assault and battery. Number 14, plaintiff realleges paragraphs 1 through 7. Number 15, due to the unlawful acts of the defendant, the plaintiff suffered a series of assaults and batteries upon his person, including arrest, handcuffing, imprisonment, physically searched, forced fingerprinting, and booking procedures and harassment. Therefore, plaintiff demands judgment against defendant as his liability appears in the sum of $10,000 together with the costs and disbursements. And he gives a date and then signs it. Puts his address. Cool stuff, straight ahead. Doesn't seem too complicated, right? Short and to the point. All right, here's another, some more paperwork that he puts in. This is the Memorandum of Law on Arrest Without Warrant that he mentioned earlier. It says, comes now the plaintiff, Charles A. Weisman, a free citizen of the state of Minnesota. I don't know if I would put that. But anyways, who respectfully presents and submits this memorandum as evidence and proof of the prevailing and controlling law regarding the matter now before the court. What do you guys think about that? Charles Weisman says, a free citizen of the state of Minnesota. Do you think that's could be a problem?
I avoid that word citizen, personally.
Yeah, I would just say a man. Or a man a citizen of the kingdom of heaven, Philippians 3:21. I wouldn't use state of Minnesota. I would say Minnesota Republic.
One of the people.
Yeah. Anybody else have any other ideas?
Well, I kind of called in late. This is Brent.
Hey, Brent, welcome.
So I've talked to Maria about this, but I'm skeptical of the people of a republic.
Yeah. You could just say a man. You don't have to say. You don't have to reference any designation of geographical designation or jurisdictional designation.
Yeah. But he's also calling himself a plaintiff in the same sentence.
Right. Yeah. So, I mean, for me personally, I would have to change some things on this paperwork. But nonetheless, there's a lot of good points here. Would you agree?
Yeah. This entering it. Yeah, I'm a little bit confused, or have questions about where you would, if you wanted to appeal to someone or their system. I don't know if the state courts would be the place. I would maybe argue you'd have to go into the federal court, but just based on how the U.S. system is set up.
Right. That's something to be looked into later on. It's like, actually, where would you file this paperwork? What would be the venue?
Also, the issue of paying their fees to file a claim or start a case, and the latches that come along with paying that fee.
Meaning, if you're paying a fee, you're giving the court jurisdiction.
That's one of them. Mm-hmm.
Well, I mean, if you're going to put in paperwork to any court, you're calling on their jurisdiction to adjudicate the matter. It's just a matter of moving the right kind of court. From what I've heard, these people in the black robes wear different hats in different situations. They could be in a legal jurisdiction or operating legally, and then it could just flip, and now they're dealing in common law or that type of jurisdiction or that type of case.
Yeah.
I don't know. I don't have experience with that. I mean, I've heard that before.
If I might make a suggestion.
Yeah.
There's such a thing as a small claims court. Usually the small claims go up to $3,000 or $5,000. No attorneys are supposed to be in there. It's between two people who have a controversy. I think you can pay the small fee to get into a small claims court, present your case, and probably have a good chance of winning. I yield.
Yeah, I've heard that before, and I've heard people have success with that. Now, the situation was regarding something to do with debt. This is a whole other ball game, which I don't see why it wouldn't work. I mean, if you put your paperwork in there, what's the worst they're going to tell you? This is the wrong court, and then you just have to.
You have a claim as an individual, as a tort. I was wrong. It's just like somebody trespasses or their dog bites me or something.
Right.
We can go to the small claims court.
Right. Yeah.
When he stopped me, he injured me.
Yep.
That's what the law says.
Right.
He had no probable cause, no reason to stop me, except he has a badge and he gets paid for the number of tickets that he writes each month.
And he carries a gun.
Yep.
And he has his cohorts supporting him. Yeah, I totally agree with you. But again, when we're looking at these things, and I don't know all the experience, everybody has on this call. Me personally, I don't have a lot of court experience. I don't care to have a lot of court experience. Some of these guys are here, they say, I've been in court 250 times. I'm like, what are you doing to get in court 250 times? You know? But, you know, I don't know about your experiences, but I don't get pulled over often. I mean, over the past 10 years, I got pulled over 3 times. But nonetheless, it's just, you know, when you're not experienced doing certain things, we like to look at other people that have experience or try to find people who have experienced these things, and especially if they've had success. So we look at that. But apparently Charles Weisman has had some modicum of success, and we see here clearly, and it doesn't even have to be with this PDF or this information, we see clearly that the law is on our side. It's just learning how to use, I guess, I don't know if I'm putting this the right way, but learn how to flip the system. Because apparently the system can be flipped in our favor. It's just, I guess, knowing how to do it, or just having the confidence and the faith to go ahead and do it. Anyway, anybody else?
Yeah, let me just mention, in the state of Georgia, the small claims court limit, or it goes up to, is $15,000.
Yeah, same thing here in the Commonwealth of the Pennsylvania Commonwealth. Yeah, it's probably different in counties around the country. It's easy to find that out and just look it up online. Your particular small claims court in your area, they'll tell you what the limit is.
But just think, if you get 1 or 2 of those guys that go to small claims court, and it costs them even $3,000 or $5,000, comes out of their back pocket, they're going to tell their buddies.
Yeah.
And they may not be so anxious to go out and be policy enforcers instead of peace officers like they're supposed to be.
Yeah. Have you had any experience of litigating against the policy enforcer?
Yes and no.
Would you mind sharing your experience?
I have my own process. Well, I'm a firm believer in what I've done in my county here. I have a document that I did in 2004 called Act of State, which makes me an international ambassador of the Kingdom of Heaven, internationally recognized in a United States treaty document, but I haven't used that one. The one I use the most is I have the oath of office of the governor, all the players in my state, all the players in my county, the sheriff, the county attorney, the county commissioners, recorder of deed, the judges. And in that I say, I, my name, first, middle, and last, standing in God's kingdom without the United States in all caps, accept for honor, value, fact, and consideration your oath of office. Now you and I have a private binding contract that you will protect and defend all of my God-given and constitutionally declared rights. I date it, get 2 witnesses, get it notarized, and one way or another I present it to them. Usually I try to do it in person and tell them I'm not here to cause problems or anything, but they work for me, and their job is to protect my rights.
Now, do you bring that into a de facto court if you're summoned?
I don't go to court. I haven't been to court since I went to prison. And I can tell a story probably even better than Chris's up there. But that's long, and it's neither here nor there. I've learned many things while I was in prison. There are a lot of good people there that shouldn't be there, and they're smart people.
Well, maybe there'll be a time where you could share that with us. That'd be good.
Well,
if you want,
if you accept their oath of office, they cannot do anything to you. I don't care what Constitution. People argue about, well, which Constitution did they take an oath to?
Yeah.
I don't care which Constitution, because I'm talking about my God-given rights. And they all swore to do that. And when they don't, then you can go down and find out who handles the insurance policy for the city, county, state, and make a claim on their bond. That's how I learned this in the very beginning, by pure accident. We had someone was getting rousted around by a judge and the police, of unlawful arrest and everything, and I tried to represent him to begin with, and then they found out I wasn't a bar card attorney and wouldn't let me see him anymore. So we asked to see the judge's oath of office. Well, they wouldn't give it to us. So this guy was working with me, said, well, what can we do now, Dave? And I said, well, I got an idea. Let's walk across the street to the county office and talk to the treasurer. We went over there, and this little girl bounced up happy as could be. Yes, sir, how can I help you? And I said, can I get a copy of the county budget? She says, oh, sure. And she brought me back one. She says, do you need another one? I said, no, this will be fine. Thank you very much. And she says, okay, thank you. Have a nice day. Well, we looked down there where it said insurance. And I was in the insurance business at that time. I knew the agency head, not real personally, but I knew who he was because he belonged to some associations I belonged to. So I just gave the information to these other guys, and they went down to the insurance agent's office, told him the story. And he says, well, that sounds like a claim to me. He said, I'll turn it in. He turned in the claim. Within 2 weeks, they pulled the judge's bond. And within 6 weeks, they were prosecuting the judge for all the crimes he had committed on the bench.
Wow, nice. And so you got the insurance.
And it's simple.
You got the insurance information from the county budget records?
Yeah.
Oh,
yeah. That's public information. You can do the same thing at the state. You're entitled as a, quote, citizen, unquote. It's public records, and you're supposed to have access to them. Now, I've found out that recently in our county they changed their system, and it's very difficult to find. And I'm working with a guy in another state that they've tried to hide where they put things. They put it on more as a debit basis instead of a budget basis. In other words, what they're spending money for, but they don't tell you who has the contract. But if you scratch it around enough, you can usually find it, especially in the smaller communities.
Yeah, that's something to keep in mind. Well, thanks for sharing that.
You're welcome.
All right, anybody else?
I had a question for the gentleman. I'm not sure who was just speaking, but would you elaborate on your international law? What you mentioned that you hadn't used yet, or what brought you to that?
Well, I was trained under a guy by the name of Clyde Edward Powell. He was in the Navy, got court-martialed 4 times, acted his own behalf, and got out with a honorable discharge. He went to work for the post office, and people found out that he knew a little bit about the law and how it worked. He lost his first 17 cases when he was working with civil rights and employment operations, and he won 317 in a row. He went to the Supreme Court as an individual, not a lawyer. He wasn't an attorney, didn't proclaim to be a lawyer, but he took cases to the Supreme Court 6 times and won all 6 times. It was on a first-name basis with Judge Rehnquist. They called him that guy from Arkansas. And Clyde used to drive up and down. He lived on the state line between Arkansas and Oklahoma, and for kicks, he used to get in his car and drive up and down the highway in Oklahoma at 80 or 90 miles an hour until somebody pulled him over. And they pulled him over, find out who he was, and they said, Clyde, go back to Arkansas and leave us alone. He says, no. He says, you can't do that. There's a federal warrant out for me in Oklahoma. He says, handcuff me and take me in. No, we're not going to go back to Arkansas, and leave me alone. He had a series of things, but the thing he created and was going to take down the whole country before his untimely death, they killed him with some injections of stuff that caused his death. But he had a document called Archetype Apostille, Act of State, and the title of it was Reaffirmation of Dual Citizenship and Renunciation of Attempted Expatriation. And that's what's happened to everyone in the United States through the birth certificate and everything. They have been expatriated from their birth state to the District of Columbia. And this document, if you know the rules of evidence, a presumption or assumption can be rebutted with equal or greater evidence. And so he designed this document that pierces a corporate veil and says who we are, and gets it notarized and takes it to the Secretary of State to get it apostilled, and then it becomes an international treaty document because that apostille is based on the 1961 Treaty of The Hague, where it's called the legalization of foreign documents. And I helped about, 200 or 300 people get that document all over the United States, and that's what I went to prison for. So it's a joke, the whole thing, but they don't like it because they got no answer for it. They're committing treason when they break it, when they go against the United States treaty.
How long were you in prison for?
6 years, a little over 6 years. And that's another thing I might say. When I was by allocution, I made one big mistake, and that's the reason I went to prison. I did my whole thing. I read my act of state, accepted their oath of office and everything, put them on notice. And the judge said, "Thank you, Mr. So-and-so, 60 months. And I said, "I do not consent." Well, he got a little huffy. 60 more months. I said, "I still do not consent." 60 more months. I said, "I do not consent." 60 more. And about that time, the prosecution, judge, you can't do that. And he was splitting spit and everything at the mouth, red-faced. "Well, what can I do?" "Well, there's a whole bunch of other charges here." Well, they ended up giving me 15 more months. And I didn't say one more time, "I still don't accept," or consent, rather. That's the secret right there. It's in the second paragraph of the Declaration of Independence. Governments are instituted among men and derive their just power from the consent of the governed. If they have their oath of office where they said they support the Constitution, it doesn't really make any difference because the Declaration of Independence is the founding document for this country. And that's the original trust created between the people and the government.
Can we talk, have you ever read the last line of the Declaration of Independence? This is kind of what I'm still trying to figure out.
Many times. We pledge our fortunes, our faith, and our sacred honor.
Yeah, and then that's all the signatures. So
57 of them, and they all met with kind of weird deaths.
Yeah, but would you agree that those are the people? I'm a little bit confused whether the people who are mostly citizens are actually the people. It's been argued to me that the people that sign and self-determined on an international basis are the owners of the government and their posterity, not all the colonists.
I don't know. My people came here and were friends with Miles Standish and Pocahontas and Captain John Smith. We go back that far. But the Constitution starts out, "We the people, in order to form a more perfect union, ensure justice, domestic tranquility, ensure blah, 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 do ordain and establish this Constitution for the United States of America." Okay, and I don't care about the posterity and stuff, and maybe the people didn't at all, but the people that went there were representatives of the people of their county, supposedly. But anyway, it says right there, and it took me a long time. I got with a bunch that says there's the Constitution of the United States and the Constitution for the United States. No, I think what they said is true. This is the Constitution for the United States of America. Having a military background, we operate under standard operating procedures. And that's what that was. These are the procedures that you're supposed to follow, which they haven't, but anything that's outside of that, we should have a tort claim individually or collectively against all the people that are making all the stuff today. I was halfway laughing today. I watched the whole proceedings for the impeachment of President Trump. I was listening to these idiots up there talking about the republic, and then we have to vote to save our democracy, and they don't even realize what the hell they're saying.
Yeah.
But they're saying the truth. Maybe I think it's unknowingly, but they're trying to save the democracy, which doesn't exist. It's gone. It went away, according to 2 or 3 places I've read and heard, several times the day after the election. The bankruptcy of the corporation, the United States, is gone. So Biden won an election to be president of a non-existent something, I don't know what. So that's a problem with the United States corporation. Clyde taught us, to be a recognized internationally, you have to have a landmass. Well, the corporate United States never had a landmass. That's the reason there was 2 flags. The Admiralty flag over the water and the Slick flag, which is the de jure American flag. It's a battle flag, but it's still the American flag that the president is supposed to operate under, and maybe the old commercial flag with the stripes going the other way is the right flag. I'm not going to argue that. I know under their rules, under 4 United States Code, it talks about the flag, and they only talk about the flag with no fringe around it. It just depends on how you read things. There are a lot of constitutional scholars that would totally disagree with me.
Well, I came across this court case. I was reading some stuff today. It says U.S. Supreme Court ruling, no corporate jurisdiction over the natural man. When people start talking about the United States and the Constitution and all this other stuff, it's just an abstract and the imagination of men, really. And it's interesting. I've thought that for a while, and I read a little excerpt from the case.
There's a court case. I can't tell you which one it is now, but the plaintiff has to be, their name has to be their complete Christian appellation. In other words, all 3 Christian names or 4 names, however many are on your birth certificate, in upper and lower case.
Yeah.
And then if you read Brady versus the United States, you can never give up your sovereignty, knowingly or unknowingly. In Marone versus the Jicarilla Apache Indians, 1996, Judge Rehnquist wrote, the idea that sovereignty could ever be relinquished puts the whole idea of sovereignty on its head. And the very first case that came before the Supreme Court, or one of the very first ones, was Chisholm versus Georgia. They said the sovereignty resides in the people.
Yeah, there's plenty of cases that talk about this, but I want to read this one excerpt. This is a little paragraph. This is apparently from a case Penn Hollow versus Doane's Administrators. Supreme Court ruling, no corporate jurisdiction over the natural man. Supreme Court of the United States, 1795. Inasmuch as every government is an artificial person, and abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons and the contracts between them. Pretty interesting.
That's true.
Yeah.
But when we go in front of them, when do we deny our corporate existence?
By claiming that we're a man.
Well, prove it. How are you going to prove it to them? Well,
that I'm a man?
Yeah.
I'll go over there and spit on them. No, I'm only kidding.
Well, so they presume you're a corporation because of a birth certificate, and that's what they have now. That can be used against them. But there's another court case that when they did away with common law after Roosevelt took over in 1939, Erie Railroad versus Tompkins. And basically that put everything into equity. No contract, no case. Then a year later, 2 years later, under the Clearfield Doctrine, when the United States comes into commerce, it becomes the same as any other individual engaged in commerce. They lose all their sovereignty. If I can't do it to you, you can't do it to me, they can't do it to either one of us. Not under that doctrine. But they don't care. You know, they're crooks. They're liars. That's the problem we got.
Yep.
But we can, if charged with anything, demand a trial by jury, not a jury trial, a trial by jury. And we have a right to question the jurors that are selected for the panel.
Do you think at these lower court levels that the lying is unwitting? I can't help but think that when you're going into some of these county courts or even state courts, the judges don't really know what you've all been talking about. Don't even know.
No, I had a person I used to be good friends with. I made him about $200,000 on some investments, but he won't talk to me now. But he was a judge, and he says, I agree with you, Dave, but that's just not the way we do it. So if they're going to keep their judgeship, they have to fall in line and follow their rules that they make up.
Yeah, well, they take oaths to the Bar Association, et cetera, too. So I don't know where their allegiance isn't to the common.
Well, that's the reason you get the oath of office. I had 2, maybe 3 judges in my case before I went to trial that recused themselves because I had their oath of office and I put it in the court record. They brought out an old retired judge, that was a hang 'em high guy.
So, Dave, do you think what we're going through here is a waste of time?
No, it's very, very pertinent.
Oh, okay.
Knowledge is power. The more knowledge you can have, the more power that you can exert, and the confidence you can have if you go in there to mess with the clowns. The lawyers don't know the laws. All they know is procedure.
Yeah.
If you really want to stump one of them, I haven't done it yet, but I've talked to some people when I was in prison. In fact, my roommate went to the Supreme Court and got an old roommate of his out of prison. But if you really want to stump them, when you go into trial and the prosecution gets up there and starts talking, you just raise your hand, Judge, I object. And the prosecutor is testifying to facts that have not yet been presented into evidence.
Besides, he's not the accuser anyway.
But he's testifying to facts that have not been presented into evidence.
Got to shut him down, right?
Then I had a guy the other day had a really good thing. If they deny that motion to you, then you say, I move for a fair trial. Now what's the judge going to do? Decline your motion?
Yeah.
Then you got an appeal right there on the spot. We're going to have an unfair trial.
We've got another big challenge going on, and it's this COVID-19, and they're keeping us out of all federal buildings now. And I don't think they're going to let up with that nonsense. You can't even...
Why would you want to?
Well, I don't want to, but they're interfering with our ability to use our courts.
Well, you can ask them for their authority. Upon demand, they have to identify themselves. And if you read the Universal Bonding Code, they're supposed to have a business card, all of them, preferably with their picture on it. And on the back, it's supposed to have their bonding information, their authority, who their supervisor is. There's about 5 different things that are supposed to be on there. If they don't have it, maybe they aren't who they say they are. But at least you can get their business card, then you can accept their oath of office, go back again, give them a copy of it, and say, I want to go in. You know, like the people said in the last week, you know, this is our house.
Right.
Also, too, is there
some people tore it up, but you know, who pays your salary?
They could also be charged with impersonating an officer.
They all are. They're all impersonating officers. They're not officers to whatever they say they are.
Yeah.
And the fact that all their statutes, rules, and regulations, if you read Article 1, Section 7, Clause 18, all their rules only apply to Washington, D.C.
Right.
Oh, the kingdom of heaven is a little bit of leaven that a lady took and hid in 3 measures full of flour. And what happened to the leaven? Well, it grew and it grew. It expanded by the hour till the flour was all leaven, and the leaven had such power that it spread and it spread out the jar to the floor, out the house to the field, and it could not be concealed. Oh, the Lord has made a place, you see. In his house are many mansions, and there's one that's there for me. If I seek his face and grow in love, Jesus washed me in his blood, and that's the key. Oh, the kingdom of heaven is a mustard seed that sprung up in a crack in a wall in the field. And what happened to the mustard? Well, it sprouted and it strained, and it split through the stones, and it could not be contained. And the crows and the cranes built their homes near its trunk, on a branch thick and strong, and that's where they sing their song. Oh, the Lord has made a place, you see. In his house are many mansions, and there's one that's there for me. If I seek his face and grow in love, Jesus washed me in his blood, and that's the key. Oh, my Father made the leaven and the mustard seed. See, it's here in my heart, and it never will depart. Though I speak and I sing to the world I'm living in, and the words that I speak are the joy and hope and peace of the one who can love from below and to above, and beyond and before, and for always evermore. Oh, the Lord has made a place, you see. In his house are many mansions, and there's one that's there for me. If I seek his face and grow in love, Jesus washed me in his blood, and that's the key. Jesus washed me in his blood, and that's the key.